Hello, everyone. I'm John Newstreet, President and CEO of the Kissimmee Osceola County Chamber of Commerce, where we are collectively champions for business and community. So today's live stream, once again, is a Facebook Live thread. So if you have questions for our speaker, we encourage you to post those into Facebook. We'll monitor that, answer them as they come along. It's a hefty topic and a lot to talk about, so I want to get to the speaker as quick as we can here. Today's topic is known by everybody in business, but certainly avoided. It generally plays out as a last option, but it is one of the more important tools to keep in your toolbox. And so, without further ado, we're going to be talking about bankruptcy today, and our speaker is Roy Kobert. Roy is a shareholder at the GrayRobinson law firm, which is a great friend to the Kissimmee Chamber of Commerce. We appreciate Roy being with us today, and as Christina brings him up onto the live show with me, welcome, Roy. How are you?
I'm great. Thank you, John.
Yes, sir. I'm gonna get to your bio and then hand it over to you as quick as we can because there's a lot to cover. We were talking in the green room just before that Roy's quite accomplished. He has a 6-page resume, so he relieved me of having to run through all of that. We'll keep it brief. But his areas of practice are alternative dispute resolution, banking and finance, bankruptcy and creditors' rights law, hospitality, and litigation. Again, he's a shareholder and resident in the Orlando and Tampa offices of GrayRobinson. He's a member of the firm's Bankruptcy and Creditor Rights Practice Group. He's certified specialist in business bankruptcy law by the American Board Certification, accredited by the Florida Bar since 2003. He's lectured for the Florida Bar in the National Business Institute on bankruptcy and insolvency issues. He's also served as a professor a visiting professor at University of Florida College of Law, Florida A&M Law, Florida Gulf Coast University, and Mountain State University, a graduate of the University of Miami and University of Miami Law School. Go Canes. And in 2013, he was named a fellow at the Litigation Council of America, a trial lawyer honorary society comprised of less than 0.5% of American lawyers. The fellowship is a highly selective and invitation-only society. And so, as I mentioned, he's quite accomplished, and we appreciate you taking the time to be with us today and to share your knowledge and expertise with our members on bankruptcy.
Fantastic. Thank you, John. I made John 4 promises, and all of you will see if I live up to those 4 promises. 1, your time is valuable to get you in and out of here in less than 25 minutes. Number 2, my rule of thumb whenever I publicly speak is that you will leave here today learning something you didn't know before. And if at the end of 25 or less minutes, you learned absolutely nothing, then I failed you. The third thing is that I will try to cover things that you haven't heard before and try to keep you on task and get you on your way. So let's go ahead and get started. I'm a big believer in visual aids, so here we go with the PowerPoint. What I'm going to be talking about very, very briefly, and feel free to feed questions as they come along, and I'll try to answer them in real time. If I don't get to your question, that just means it's going to come up in a future slide. What I'm talking about very succinctly is something that's very topical, that's happened in the past 60 days. It really is the intersection between this COVID-19 pandemic and bankruptcy. Next slide. For those who have not been living under a rock or a bubble since we've declared a pandemic in the last 60 days or more since February, you can see the list of companies that were on the verge or filed since the pandemic was declared. Some names you may not recognize, some you may, including J. Crew, J.C. Penney, Needless Markups, and Pier 1 Imports. And Florida, next slide, is not immune. We've had even Florida companies, a company called Klausner up in Live Oak. They're a paper mill manufacturer. I was surprised because I thought you need paper mills to make toilet paper. Who thought a toilet paper company would be filing bankruptcy? One of my faves, 2J's, including some restaurants. And then trying to keep it topical, Friday night, So it's just made the headlines today or yesterday. The business news was the filing of Hertz Rent-A-Car and its sister companies, Thrifty and Dollar Rent-A-Car, that are based in Estero, Florida, over in Lee County. So the wave is coming, hopefully not a tsunami. Next slide. And some companies don't even have to file bankruptcy. Sweet Tomatoes, I love their free ice cream in Florida. They decided, you know what? We're not even going to reorganize. We're not even going to try. They just went dark. They didn't even file bankruptcy. They just shuttered all their stores and they're out of business. Next slide. I think the Greater Orlando Aviation Authority said it best, is that we know that a lot of our concessionaires are going to have a tough time coming back. Business is down 95% of the airport, which is obviously a very economic and important driver. It was the number one airport, close to 50 million deplanements in last year, more than Miami International Airport. And the Angola realizes as they build a new terminal that there'll be some concessionaires that will be forced into bankruptcy and unfortunately may never come back. And that was reported in the Orlando Sentinel on May 8th. Next slide. So what shape is this recovery going to look like? We all hear about shapes. Is it going to be a V quick shape? I think the answer is no. Is it going to be an L shape where we go down and we stay down? I think it's safe to say the answer is no. Is it going to be a U shape? I think the answer is yes. It looks like a smile. I hope it is a smile. The question is, how long is that U shape going to be? We just don't know. It is still too darn early. And I'm hoping the U shape is short. Next slide. Now, I promised to teach you something that you wouldn't have learned anywhere else. I'm not big on Italian. Some of you know Italian words better than I do. But the word bankruptcy comes from banco rata. I'm probably butchering the word, which means broken bench. The way it worked nearly 1,000 years ago is you went out fishing and you came back with your fish catch and you dried it out on your bench. But if you didn't pay your bills while you were out fishing, someone came along and broke your bench. And that was a symbol to everyone else in the fishing community that you didn't pay your bills when they came due. So bankruptcy, the word means broken bench. You can impress your friends in the next cocktail party to explain what the word bankruptcy means. Nothing to do with the PowerPoint slide today, but at least you've learned something here today. Next slide. We saw in the Wall Street Journal last week, they're predicting which metro areas will come back and when they will come back. Unfortunately, Orlando being a tourist-driven economy, they predict that Metro Orlando will be one of the last to return to its pre-heights in no sooner than 2023. Again, I'm hoping the Wall Street Journal is wrong. Next slide. I promise not to get too granular on you, but I must just quickly touch on this. You don't have to digest it all, but there's this thing called the Small Business Reorganization Act. This was actually passed pre-pandemic. It went effective on February 19th, 2020. By sheer coincidence, my 30th wedding anniversary. And it came up with a way to come up with what I call the Poor Man's Reorganization Act. As long as you had business debts, both liquidated, contingent, non-contingent, secured, unsecured, under $2,725,000, you were able to put together a quickie Chapter 11 reorganization, because Chapter 11 is expensive. It's faster. You have a status conference in 60 days. You file a plan in 90 days. Creditors can vote on your plan. There's no absolute priority rule. Equity gets to keep the equity in the business as long as the plan is fair and equitable and fair to creditors. which amazes bankers. You can modify the home mortgage because typically when you go for these small business loans, you typically have to put up your house as collateral, and you can modify the home loan as long as the house wasn't acquired with a purchase money security interest. But again, I'm getting granular. It's cheaper. There's no creditors committee. There's no U.S. trustee quarterly fees. There is a trustee whose job is to help you negotiate a plan terms with your creditors. So it's fast and it's cheap as long as you have less than $2.725 million of secured and unsecured claims. Now, not a lot of case law. It hasn't been in existence that long. Next slide. Then all of a sudden comes the CARES Act, which you've heard tons about, the PPP, keeping people employed, etc. The $2 trillion stimulus put forth by our elected officials in Washington. What's important here is buried in the several hundred pages of this act that took effect on March 28th. It temporarily modified what I talked about a slide ago, the Small Business Reorganization Act. It increased the eligibility limit, from $2.725 million of secured and unsecured debt. It tripled it to $7.5 million. And I'll bet you that most of our elected officials in Congress had no clue what this was doing here. So for a period of now 10 months left until March 28 of 2021, businesses are eligible to file under the Small Business Reorganization Act with debt limits up to $7.5 million. It's only for the next 10 months that remain. After that, it sunsets in a year on March 28, 2021. So it's a wonderful opportunity to take advantage of the Small Business Reorganization Act as it triples in size of who is eligible. But again, most people don't know this is only for the next 10 months. So keep this in your toolbox as an opportunity to take advantage of this that Congress created, much to their chagrin. Next slide. On the creditor side, I get asked, boy, what are some of the sexy things you can do in bankruptcy? You can turn, when I tell my banking friends this, they're in amaze that you can do this. You can turn an existing first mortgage into a second mortgage. And you're probably saying, how the heck can you do that? If you have a $1 million asset and you have an existing, let's say $600,000 first mortgage, and you go to your bank and say, hey, I'd like to borrow another $200,000, typically your bank will say, no and heck no. I like having a 40% equity cushion, and refuse to do so. However, if you file bankruptcy and you have the court determine that the asset is worth $1 million, with court approval, you can get an additional $200,000 loan and make that new $200,000 loan a first mortgage and take the existing first mortgage at $600,000 and push it down to a second mortgage. Where else, only in America, can you take a $600,000 first mortgage and poof, with a court order, make a $600,000 second mortgage? Only under the bankruptcy code. Quite amazing to do this with a priming lien. What else can you do that's kind of magic? Next slide. Creditors also have certain rights in bankruptcy. And here I'm going to focus on those of you who are commercial landlords. Typically, the debtor would have the ability to keep extending the time to assume or reject the lease. Well, that law was changed back in 2005. The commercial debtor gets a 90-day extension of time to decide if it wants to assume or reject your commercial lease. They can get one additional extension past the 60 days for a total of 210 days to assume or reject leases. That's it. They can't go on forever. The only way they can extend the time to extend past 210 days while they're remaining current to assume or reject a lease is if the landlord consents. Absent the landlord's consent, the tenant cannot go past 210 days as he continues to service the lease. Two other points I want to bring up is some Delaware judges got cute. If you filed bankruptcy, if the tenant filed bankruptcy on April 9th, they would say no rent is due in April. Why? Because rent is due on the first of the month. And if they filed on the 9th, no rent is due. I think that's silly. Most Florida judges think that's silly. If the debtor is going to file on April 9th, it doesn't have to pay pre-petition rent, but the rule of thumb is it's got to pay stub rent. What does that mean? It's got to pay rent April 9th through April 30th. That would be 21 days of rent must be paid. But if you don't ask, you don't get. You got to go and say, Judge, make them pay the 21 days of April rent. And then the debtor has to start making rental payments within 60 days after the bankruptcy. Again, don't ask, don't get. If the debtor is not paying automatically the May and June post-petition rent, you need to go to court and say, Judge, the code requires them, make them pay the May and June rent. There's no such thing as a free lunch. Next slide. However, there's an exception, and I'm embarrassed to tell you about this. It's called Pier 1, and it's this whole idea of mothballing. The Delaware judge said this is a very unusual time, and obviously the biggest expense Pier 1 has is servicing its landlords all over the country. Well, Pier 1 needs to buy new goods to restock its shelves. Pier 1's got to pay its debtors, lawyers, etc. So the judge in Pier 1 said, I'm going to make the Pier 1 landlords take a time out and wait while Pier 1 decides what's going to go ahead and do, which I think is crazy. The Pier 1 landlords have obligations to their lenders. What are they supposed to do? What happened here was the landlords became what I would call the coerced lender. They didn't get April rent, they didn't get May rent, nor did they get March rent. They were told to stand down and wait and let it accrue, which I think is not only wrong, but contrary to the bankruptcy code. But it's nice to be the judge, and the judge in Delaware did this. I would tell you right now, I am aware of no Florida judge which would ever do this. And what happened 10 days ago? Pier 1 decided, you know what? We can't make a go of this. Isn't working for us. And they ended up going dark. Who ended up paying the ultimate price for that? The Pier 1 landlords. They now have an administrative priority claim, big deal, but they did not get paid March, April, and May rent. A terrible, terrible precedent, and hopefully we'll never see mothballing like that again, and I'm embarrassed to tell you about that. Next slide. Now, if the tenant wants to assume the lease, it has to do the following. It has to cure the post-petition rent, and also if it hasn't paid rent pre-petition, it has to cure that in full. And it has to assume the lease, warts and all. It can't say, I like this portion, I like that portion. It has to accept it all. Anti-assignment clauses are void. What that means is that they can't cherry pick what they like in the lease. They must take it all. If you have Pet Supermarket as your anchor tenant, they can't bring in a new tenant that sells birds because you gave the exclusive for selling birds to Pet Supermarket. They can't do that. So tenant mixes will be enforced. If they want to bring in a new tenant to take over, that new tenant must be at least creditworthy as the debtor. Conversely, if the debtor says, you know what, this lease makes no sense and wants to reject it, unfortunately, you don't get the balance of the lease term as rejection damages. Let's say you have 10 years left to go. You don't get 10 years of rejection damages. There is a liquidated sum that you get, which is either going to be 1 year of future rent as your liquidated damages that has to be paid, or 15% of the rent over 3 years, whichever is greater. I will typically tell you that 1 year of future rent is typically the higher amount of rejection damages that must get paid by your debtor tenant. Next slide. Vendors have certain rights. If you delivered goods or services within 20 days prior to the bankruptcy, you have a right to get your stuff back, as long as your stuff has not been installed into a widget or built into a component part. If it's sitting there on the showroom floor, you can tell the debtor, either pay me for what I delivered 20 days prior to the bankruptcy, or you must deliver it back to me. That is a very, very powerful tool for you to put back into your system, rather than letting the debtor keep it for next to nothing. The other issue is critical vendors. If you happen to be the only vendor that provides this one critical part that the debtor needs for its production facility, you could be considered critical. And if you're labeled as critical, then the debtor must pay not only what's owed post-bankruptcy, but pay what's owed pre-bankruptcy. As you can imagine, some vendors have taken advantage of that. This occurred in the Kmart case, where every vendor said, I'm critical, I'm critical, I'm critical. And what happens there, the exceptions swallow the rule. Not every Kmart vendor is critical. I think you're critical if you deliver a part or do some sort of service that cannot be replicated anywhere else in the United States. You must speak up and say, I'm a critical vendor, and if you want to keep my part, then you need to not only pay me for it, even if it happened pre-bankruptcy, because typically the debtor does not have to pay for what transpired pre-bankruptcy, but only pay for what occurred post-bankruptcy, except if you are a critical vendor and assert reclamation rights. The bottom line is, be the greasy wheel, speak up, say something. If you don't, your rights will get run over. You must be the squeaky wheel. You must participate in the case to take advantage of the bankruptcy rights that the bankruptcy code gives you. If you don't, nobody else will speak up on your behalf. Next slide. Wow, 2 minutes to go. I covered it all. I know it went very fast. I apologize, but hopefully there's one thing that I said to you today, other than the definition of bankruptcy, that caused you to say, I never thought of that before. And if so, I accomplished my goal.
Roy, you did great, and we appreciate it, of course. We got just a few minutes for questions, so if anybody watching live has those, please put those in the thread. We'll get to the question as soon as it comes in. To continue the conversation for these few minutes, though, first, wanted to ask the question in layman's terms of the benefit of bankruptcy. You talked about sweet tomatoes going dark. Is there a benefit to going dark, or is there a benefit going into bankruptcy? And can you highlight that?
Sure. The benefits of going into bankruptcy is if you want to reorganize. You find a lot of these companies, they want to basically get rid of what I call the bad leases, the leases that don't make any economic sense, or leases they may have below market, and they want to sell those leases to third parties, and they want to come out leaner and meaner and smaller than they were before. Sweet Tomatoes decided they don't want to come back leaner and meaner. They're just going to go out of business. And I typically recommend, if you're going to go out of business, don't file Chapter 7, because all you're doing is inviting the Chapter 7 trustee to give you a Klieg exam, to ask you questions about, why did you do this with the money? Why did you bonus out your management? Why did you show favorites to friends and family or to your favorite vendors? All you're going to do is get second guessed till you're blue in the face. So you're better off just going quietly into the dark and going out of business.
Mm-hmm. And if you're a small business and maybe bankruptcy is not even an option, it's just, is there a step you take filing with the state that you're pulling your license? Is there something simpler for a small business who doesn't have all those other variables?
Sure. There's a statute, again, not to get too granular, called Florida Statute 607. You talk to your corporate lawyer, and it's a way of you write a letter to all of your vendors saying, hey, I apologize. We couldn't make a go of it. We're in the process of on our way of liquidating our assets. We're going to write you a letter and tell you that we got 5 cents in the dollar and we're going to start cutting checks. We apologize and we wish you all the best. Goodbye.
Sorry about that. I got an incoming call on my phone. So technology. So I appreciate that. And I guess the other question would be the benefits of an attorney. I'll encourage you to brag about yourself and the pedigree you bring into the discussion and the benefit that might bring to a business owner or a team that are looking at bankruptcy as an option. Is there, you don't want just someone who's coming out of school necessarily, or does that matter? Just talk to that, brag about yourself.
Well, you don't need a lawyer all the time. You could work if you have a trusted financial advisor or CPA who could help you wind up your business and go out of business. Yes. If you're going to go into the bankruptcy realm, either as a debtor, commercial debtor, or as a creditor, going it alone, unfortunately, is dangerous. It's sort of like asking your dentist to perform a lobotomy on you. Mm-hmm. The law is too complicated and specialized to try to go it alone or to go with a generalist.
Mm-hmm. Very good. So we've got just a minute or two. I don't see any questions from the audience. So is there any parting thoughts or summary points you want to make as we exit?
No. Be patient out there. I like to think that everyone is trying to work together. We're all trying to get along. I think things will be quiet during the summer, but I think landlords, tenants, banks, everyone's going to start losing patience as we go into the fall. And that's when the gloves will start coming off. So hopefully we will not see an uptick in bankruptcy and that people will continue to cooperate with each other, realize that we're all in this together. This is not like we saw with the Great Recession, a economic issue. It is primarily a healthcare issue. And if we can get through that, hopefully we can bounce back without a dramatic uptick in bankruptcy cases. And I truly believe that.
Well, we're hoping for that U and even maybe even the V if we can accelerate the growth. But we're definitely keeping a positive outlook, and this is great information to share as another tool in that toolbox for our businesses. We appreciate you taking the time, Roy, and again, appreciate your partnership. And we'll put your information in the thread. Again, it's featured on the slide, but we'll get it in the text thread so people can follow up with you for that expert advice. And again, thank you very, very much.
Thank you. Stay safe. Wash your hands.
Yes, sir. Take care, everyone.
Bye-bye.